Chapter 19, Part 3, and here we're talking about the authority of an agent. Let me see if I can make that just a little bit bigger. Okay, hope you can see that when I post it. So agents can have either actual authority or apparent authority. Actual authority can be either express or implied. Apparent authority is based upon what the third party is reasonably led to believe is the authority that the agent has. Express authority can be declared either in clear, direct, and definite terms, but can be either in oral or can be in writing. Okay. Power of attorney, express authority. A power of attorney can be either special or general. In a general power of attorney, you're basically giving the agent, the principal is giving the agent the power to do anything that the principal can do. In a special power of attorney, the power of attorney document itself specifies the powers that the agent has. So for example, in real estate transactions where the buyer or seller cannot be present, oftentimes they do it through a power of attorney which allows the person to appoint somebody as their power of attorney to go to the closing and complete the documents. But that's all they can do, what's in the power of attorney. Okay, I want to mention to you right now, if I haven't already, that Georgia, as of about 2 years ago, adopted a new power of attorney statute which makes it much more specific as to what has to be done to have a legitimate power of attorney in Georgia. And there is a form that is provided in the statute that is supposed to be used, and it's much more detailed than the old law was. So if you expect people to accept your powers of attorney in Georgia from now on, you need to make sure that you follow that statutory provision. You can look that up easily in the Georgia statutes, and you can find the form right there in the statutes. Okay, implied authority is the agent does what's reasonably necessary to carry out the express authority to accomplish the objectives that are set forth. The authority is inferred or conferred by custom or the agent's position, and it cannot go against what is in the express authority. Apparent authority is when the principal causes a third party to reasonably believe that the agent has authority to act for the principal. This usually occurs through a pattern of conduct by the principal. In addition to this, an agent can have emergency powers. So for example, if the principal is on vacation on a safari in Africa and something comes up in an emergency, then the agent could have the authority to act on behalf of the principal. So it arises when an agent must protect or preserve the property and rights of the principal, and the agent is unable to communicate with the principal. Ratification occurs when the principal accepts responsibility for what the agent did that was unauthorized initially, whether unauthorized through express or implied actions. When the principal ratifies the agent's conduct, then the principal is bound by that. In order to be bound by that conduct, the requirements are that the agent has to have been acting on behalf of the principal. The principal must know of the material facts of the transaction. The principal has to affirm those acts in their entirety, and the principal and the third party both have to have had legal capacity when those actions were taken. The principal's affirmation must occur before the third party withdraws from the transaction, and the principal must observe the same formalities when ratifying the act as would have been required to authorize it initially. Okay. Liability of the principal for contracts formed by the agent depend upon the agent's actions and whether they were authorized or unauthorized. So principals can be classified for this purpose into three classifications: disclosed, partially disclosed, or undisclosed. Disclosed is where the identity of the principal is known to the third party. Partially disclosed is where the third party knows that they are dealing with an agent but doesn't know the principal's identity. And undisclosed is where the third party does not know the identity of the principal and doesn't really know that they're dealing with an agent. Okay, so liability, where you have a disclosed or partially disclosed principal, the principal is liable to the third party if the agent acts within the scope of their authority. The agent doesn't have a liability to the third party for disclosed principal's non-performance. And the agent may be liable if the principal is partially disclosed. What if the principal is totally undisclosed? There's no liability for the agent unless the principal expressly excluded liability based upon the contract terms with the agent, or the contract is a negotiable instrument, or the agent's performance is personal. What about unauthorized acts? If the acts are outside the agent's expressed authority, whether implied or apparent, then the agent is liable regardless of the principal's classification. However, if the third party knows at the time of the contracting that the agent has no authority, then the agent is not liable. Liability for e-contracts or e-agents. An e-agent is a semi-autonomous computer program capable of executing specific tasks on behalf of a principal. It's sort of like a robotic action. E-commerce uses e-agents to create contracts every day. Okay, we're going to stop there and we'll pick back up with part 4 of agency relationships.